Hello, everyone. Welcome to part one of our four-part employee benefits webinar series. My name is Laura Ryan, and I'm a partner in Thompson Hine's Employee Benefits and Executive Compensation Practice Group. I'm joined today by my colleague, Kim Wilcoxon. Kim and I are going to review some of the health plan compliance issues that employers should be considering when planning for 2022, as well as the end of certain rules and relief that were offered and implemented due to the COVID-19 pandemic. Next week, my colleagues Beth Mandel and Stephen Penrod are going to continue this review and discuss health plan issues that we're not able to cover in today's hour. If you've not already done so, you can register for the other three webinars that we are planning for this month through the invitation you received or on the events tab on the Thompson Hine website. Each webinar, as a reminder, does offer CLE and a certificate of attendance. To address up front a question that we frequently receive, today's webinar is being recorded and will be sent to everyone registered for the program within approximately 2 business days. During today's presentation, please feel free to use the question panel in the upper right-hand corner of your screen. We'll try to address questions both during the presentation as well as at the end as time permits. And now we'll begin today's program. So just to review the topics that we plan to cover today, we will be addressing the expiration of certain special COVID-related relief, COVID vaccine issues that are coming up now, certain updates related to COBRA, CAA readiness, that's readiness to comply with certain requirements brought to us by the Consolidated Appropriations Act, which begin to kick in 2022. We'll review annual compliance reminders and address some 2022 planning considerations, with other 2022 planning considerations being covered next week. Just as a preview, next week we'll go into depth about mental health parity compliance requirements. We're not attempting to cover that today. That's a pretty big topic, and address other topics, including the latest on cross-plan offsetting practices, sex discrimination and benefits coverage, some guidance related to fertility benefits, best practices in addressing and responding to claims, appeals, and documents requests in connection with the group health plan, lots of state and local compliance issues that are popping up and impacting group health plans, and other things to keep your eye on. So with that, I'm going to turn it over to Kim to address the first 2 topics today.
Thanks, Laura. We are going to kick off with expiration of special COVID relief. And before you get too excited, we don't know anything that you don't know as far as when this pandemic is going to end and when the emergency is going to end. But to that point, before we jump into that, wanted to just clarify when we're talking about the end of relief, a lot of the relief that we've received is limited to certain emergency periods. So we have our public health emergency, which is declared by HHS. It generally runs for 90 days at a time. And if it's renewed for 90 days at a time. So it's been renewed since 2020, most recently renewed in July. We expect it to continue to be renewed. Then we have the national emergency, which is a little different than the public health emergency. The national emergency is declared by the president. It was declared last March and was renewed again this year. So unless it is announced to end earlier, it will automatically expire in 2022 unless President Biden again renews it. So again, we don't know when this is going to end, but hoping that it ends sometime soon, we wanted to walk through a few considerations for you. This slide and the next slide show a summary of the various COVID-related relief provisions and what they mean for your plan and what the end of the pandemic means for your plan. You know, some of the changes, like the first 3 on this list, were have-to-dos, right? You have to enhance your plan to address this particular issue. When we get to the end of the relief period, whether that's, and for the first 3, it's all the public health emergency. You know, your plan doesn't have to be changed to go back to the pre-pandemic provisions. It certainly can. You're no longer required to have these provisions in place. You can return back to your pre-pandemic, plan design. Many of the rest of the items on this list are relief provisions. They're allowing us to do things that maybe we wouldn't otherwise be able to do during the pandemic. So I do want to draw your attention to one item in particular, which is related to high deductible health plans. So the CARES Act allowed us to waive cost sharing for telehealth services and still be able to participate in a high deductible health plan and contribute to an HSA. So normally, if you're in a high deductible health plan, the employer can't provide medical care before someone reaches the deductible unless it's preventive care. Well, here they're allowing us to provide any sort of telemedicine services prior to the deductible. But that CARES Act extension only extends until the end of this calendar year. So even though the pandemic may still be going on, the public health emergency may be still going on, unless we get a legislative fix, we will have to start charging again for telemedicine services for those folks who are in a high deductible health plan. And as I mentioned, the few more items on this slide, most of these are relief so that when the pandemic is over, we are going to have to look back at, implementing rules that maybe we've been able to slide on a little bit during the pandemic. Did also want to pay attention on this slide to the D-Cap exclusion. So as you may know, the American Rescue Plan Act this year increased the amount that can be provided under dependent care assistance programs tax-free. Normally we have that $5,000, $2,500 limit, which is our maximum contribution limit for dependent care FSAs. That was increased this year. If your plan did take advantage of that and increase the dependent care limit, just remember, especially as you're preparing open enrollment materials, that's got to go back to $5,000 or $2,500 again next year, again, unless we get some sort of legislative fix before then. The last item on the list is one of the only ones that is actually not limited to the pandemic, and that was our ability to reimburse over-the-counter drugs, menstrual care products, and PPE related to COVID-19. If your plan was amended to do that, it can continue post-pandemic and you don't have to worry about reversing that at the end. But when we think about changes at the end of the pandemic, we want to remember some guidance that we got from the agencies on, how to announce this. Because normally, when you make a change to your plan, we have notification obligations. If it's a change that impacts the SDC, we have to provide 60 days advance notice of the change. Well, we got some relief from the agencies that said if all you did was enhance your plan to waive cost sharing or provide enhanced benefits as a result of the pandemic, and you're just reverting back to the pre-pandemic plan design, you don't have to provide 60 days advance notice of that reversion, so long as you communicated to participants that these changes were only temporary and you told them the general time period during which they would be applicable, and you're just following what you told them already. So if you haven't communicated to your participants that these changes are only during the public health emergency or only until 2021, you might think about doing that perhaps as part of open enrollment materials, just so you cover your bases and make sure you have this communication out there so that you don't have to provide the advance notice if you then go and revert back to something that impacts the SBC. And for those with grandfathered plans, if there are any of you out there, just know that reverting back to pre-pandemic plan design does not impact grandfathered status. In addition to the relief that we got on plan coverage issues, we had some deadline extensions related to the outbreak period. And these deadline extensions impacted, several different actions, which I'm sure you're well aware of and familiar with because we've been dealing with this for 2 years, so I won't spend time on the detail. But just wanted to remind you that the outbreak period is still going on. And last year, you probably went out and told your employees that they would have until after the end of the outbreak period to take certain actions. The outbreak period is going to last until 60 days after the end of the national emergency, not the public health emergency, the national emergency. Or it could be an earlier date announced by, who knows, the Department of Labor, the president. If this earlier outbreak period end date is announced, well, then we've got the end of the outbreak period. And the outbreak period was supposed to toll deadlines. So any amount of time during the outbreak period should not be taken into account when determining whether somebody's deadline is running. We then subsequently, this year, got guidance to clarify that the regulatory agencies don't have authority to require us to extend deadlines for more than a year. So what does that mean for us? Well, if we think about the fact that you can't include the outbreak period, but no more than a year, when applying these particular deadlines, you may have thought last year about this idea. I know we had some vendors who were doing this full approach and some vendors who were doing a prorated approach. So for example, if I had an event that started a deadline clock running 10 days before the beginning of the outbreak period, under the prorated approach, I stopped my clock on March 1, and I'm going to start it again once the extension is over. So I have 50 days left to take my action. Under the full approach, we pretend that I didn't have the event before the outbreak period. We pretend that my event occurred during the outbreak period, and the full 30, 60, whatever the day is, that starts running at the end of the outbreak period. Well, with this 1-year deadline guidance, we now know that the plan doesn't have to extend those deadlines, until the end of the outbreak period. The kicker here is, though, did you tell anybody that we've reduced the deadline extension to just a year? We've got some fiduciary concerns. If you told your employees last year that they had until after the end of the outbreak period to enroll their new baby, and now we're saying, oh, well, actually you only had 1 year, but we never told you you had 1 year. So you're still thinking you have until 2022 to enroll the baby that was born in 2020, and we're saying, oops, nope, too late, sorry. So things to think about as we approach the end of the outbreak period. Have you told participants about, have you decided to shorten your outbreak period deadline extensions to just 1 year? Or maybe a period of time after you provided notice? How are you going to apply that? Have you told participants about it? Again, open enrollment is a nice time as you're talking to people about your benefit plans. If you haven't made these communications already, this might be a nice time to do that. So as we're thinking about the end of COVID relief, to sum up what we just talked about, employers are going to want to determine the extent to which the plan design will revert to pre-COVID terms or otherwise change at the end of the public health emergency or the national emergency or the pandemic. Unless that telehealth exemption is extended by legislation, we've got to reinsert those cost-sharing provisions for telemedicine for anything that's not preventive. You want to consider the extent to which communications about plan changes must or should be provided. Determine how to administer those deadline extensions if you haven't already worked that out, and determine whether and how to communicate the end of the outbreak period. When we get to the end of the outbreak period and those deadline clocks start running again, how are people going to know that? With that, I'll move then to some COVID-19 vaccine issues, and we have some late-breaking guidance that we got on Monday, which will be included in this discussion. But knowing that right now we are waiting on OSHA guidance with regard to the employer mandate for vaccines or testing, we wanted to spend some time on COVID-19 vaccine issues. So as a reminder, non-grandfathered group health plans are required to cover the cost of the vaccine and its administration without cost sharing. Now, right now, the federal government is actually covering the cost of the vaccine, but providers are allowed to charge an administration fee. So really what we're paying for is the administration fee at this point. But if we get to the point where the government's not paying for the vaccine, we'd have to cover both. Now, the CARES Act created this special enhancement to the Affordable Care Act, right? The Affordable Care Act tells us that preventive services like vaccines, have to be covered 100% in network. The CARES Act said, well, it has to be in network or out of network. Well, let me back up there a minute. The CARES Act said we're going to advance the period of time during which this has to be covered. So 15 days after a recommendation about the vaccine, non-grandfathered group health plans have to cover the vaccine. And so since, I think it was 2020, there was a recommendation in 2020 where the vaccine then had to be covered within 15 days. But we've had, different recommendations since then about who should get the vaccine and should we get boosters. And guidance that we got on Monday confirms that our recommendation has been made. That 15-day clock has run. So as soon as any adjustments to that recommendation are made, the plan has to cover that immediately. So if there's a recommendation that booster shots be given for individuals of a certain age, the plan has to cover those booster shots. There's no waiting period there. So just be aware that that guidance came out And hopefully your administrators are covering the cost of those vaccines in accordance with guidance under any emergency use authorization or biologics license application. We also got some guidance last year to confirm that an employer can provide vaccines through an employee assistance program without causing the employee assistance program to lose accepted benefit status. As you may know, employee assistance programs cannot provide significant benefits in the nature of medical care, or they lose accepted benefit status, which means they then are subject to the Affordable Care Act market reform provisions, they're subject to the HIPAA portability provisions. So we got the guidance that says, go ahead, you can provide these vaccines as part of an EAP and you won't change the compliance obligations of the EAP. Similarly, we got guidance to say that you can provide vaccines at an on-site medical clinic. On-site medical clinics are accepted benefits, so they don't have to comply with the ACA market reform rules, they don't have to comply with HIPAA portability, and in fact, on-site medical clinics don't have to comply with HIPAA privacy, which is nice. From an employer's perspective, one less thing to worry about. So you can provide vaccines at an on-site medical clinic without causing the on-site medical clinic to lose that accepted benefit status. What we don't know, and the guidance that I wish we would get, is if an employer pays for the vaccine outside of the group health plan, does that make a group health plan? In accordance with the presidential executive order, we may find ourselves in a situation where employers are mandating vaccines for employment purposes, and due to various state laws, the employer then would be required to pay for that vaccine. So if we're in that situation, or if you as an employer have decided to pay for the vaccine anyway outside of the health plan, one thing to think about is this a group health plan? And we do have some guidance from the Department of Labor on drug testing, which says that if you're requiring drug testing for employment purposes, that doesn't create a group health plan. But here we're administering a vaccine to someone, a healthcare provider is administering a vaccine to someone. That seems to be more medical care than a drug test. Even though it's solely for employment purposes, I would love to get some guidance from the Department of Labor to tell us, can we do this without triggering ERISA? If we can't, do we have an ERISA plan? Because an ERISA plan requires a plan funder program that involves some sort of ongoing administrative scheme. If all we're doing is providing one vaccination or maybe 2 doses of vaccination to an individual, is that an ongoing program? It's an open question. Would love to get guidance from the Department of Labor. Until then, consult legal counsel if you are planning to pay for the vaccine outside of the group health plan. Because remember, if it is a group health plan, we have a number of different compliance obligations that we need to think through how we would address. So moving on then to incentives. We've gotten a lot of questions about incentives, especially about surcharges for unvaccinated workers. I think a lot of those questions are being put on hold for the moment until we get the OSHA guidance. But for those of you who want to hear this anyway or are moving ahead, want to take just a minute to talk about incentives. Example number 1, we provide a gift card if an employee simply shows proof of administration. That type of incentive doesn't trigger any wellness program rules under either the ADA or HIPAA. So those rules aren't going to impact the design of the program or the amount of the incentive. Because COVID-19 vaccines are not considered medical examinations under the ADA, and proof of vaccine requirements are not disability-related inquiries, and we're not providing this incentive, this gift card, in connection with the group health plan. So none of these ADA or HIPAA rules are going to be triggered. But now let's say that cash is available if the vaccine is administered by a provider under contract with the employer. As you may remember from the EEOC guidance issued earlier this year, the ADA rules are going to apply because pre-vaccination screening questions are likely to elicit information about a disability, and so then we have our disability-related inquiries. So if we can't mandate the vaccine under the ADA general rules, we have to follow the ADA wellness program rules. Right now, unfortunately, we have no safe harbor to show how much of an incentive would be permitted under the ADA wellness program rules. That's a whole nother presentation, which we're not going to go into here, but suffice it to say that there's risk whenever the ADA wellness program rules apply. Now we get to the good stuff. Example number 3, a premium surcharge applies to medical plan participants who don't provide proof of vaccination. This is our late breaking guidance we also got on Monday. The HIPAA activity-only wellness program rules are going to apply. So that means that when combined with all other incentives that are subject to these rules as health contingent wellness programs, the surcharge can't exceed 30% of the cost of coverage. Or, there's a special rule for 50% if you're dealing with tobacco cessation programs. And we have to offer a reasonable alternative way of avoiding the surcharge for those employees for whom it's unreasonably difficult due to a medical condition or medically inadvisable to attain the COVID-19 vaccine. So an example that they gave in the guidance on Monday was if an employee attests to complying with the CDC's mask guidelines for unvaccinated individuals. That could be the reasonable alternative. And if they do make that attestation, they would avoid the vaccination surcharge. If it's reasonable to do so, if it's not obvious that there's a medical condition that prevents the employee from getting the vaccine, you can ask for proof that the employee really can't get the vaccine. The concern with this, though, it's nice because it limits the universe of people who could avoid the surcharge and still not get the vaccine. But by asking for this type of proof, are we then asking disability-related inquiries that pull in those ADA wellness program rules that I was just talking about? I think that's an open question and something to be aware of. And you should also know that if an employee's physician states that the vaccination and reasonable alternative are not medically appropriate for the employee, the plan has to provide an alternative that accommodates the recommendations of the physician. And any materials describing the surcharge have to explain that there is the opportunity to get a reasonable alternative and that the recommendations of a physician would be taken into account. In addition, the program has to be reasonably designed to promote health and prevent disease and can't be a subterfuge for discrimination based on a health factor. Interestingly, in the guidance that we got on Monday, in their example, they said that the employer is providing a hotline that people can call to find out where to get the vaccine and ask questions about the vaccine. They demonstrated that as additional proof that the program was, reasonably designed to promote health. Would you need that hotline? Would you need, additional information about the vaccine in order for this type of program to work? I don't know, but it is in the example. Now, keep in mind that the program itself can't be overly burdensome, so you can't make it difficult to get the vaccine. And the reasonable alternative can't be overly burdensome. So I'd imagine that if your reasonable alternative is you must take a diagnostic test every single day before you come to work, that's probably going to be too burdensome to be a reasonable alternative. And the program has to give individuals the ability to qualify for the reward at least once per year. Does that mean that we have to keep this program going next year? Does that mean that if we get the vaccine today, we have to retroactively put the premium back into place way back to January 1? I think there are some open questions about exactly how this requirement would apply. So again, employers who are thinking about a premium surcharge, take a look at legal counsel. Now, the last thing I want to note is that the vaccination premium surcharge is going to impact affordability for ACA purposes. So recall that when determining affordability, you look at what the employee would pay under the lowest cost option for employee-only coverage. That premium, we are going to assume that the employee completed a wellness program relating to tobacco and failed any other wellness program. So as you can see in this example, if our base premium was $100, if we had a $75 tobacco surcharge, if we had a $100 non-vaccination surcharge, then when we're calculating our affordability, our premium really is $200. Base premium plus we failed the vaccination wellness program. We don't get the tobacco surcharge because we passed the tobacco wellness program. So keep that in mind as well. If you're doing a premium surcharge, that could impact affordability, which could present a risk of the B penalty under the ACA. So considerations for employers: if you're going to pay for the vaccine outside the health plan, think about, does a group health plan exist? What's your risk tolerance? What's your legal counsel say? If it is an ERISA plan, make sure you know how you're complying with the various ERISA requirements. And if you're going to provide incentives, there are so many nuances and rules that apply to wellness programs. you definitely want to think through this and make sure you're hitting all the ones, making sure you know what does apply. And we haven't talked about all of them today. We didn't even touch on GINA. So just keep in mind that this is a very complicated world and should be done with care. With that, I'll turn it over to Laura.
You can do the slides.
Yeah, sure.
So I wanted to just run through a couple of different items impacting COBRA that we've experienced over the last couple of years. The first, of course, is the American Rescue Plan Act and the implementation under that act of a 100% subsidy towards the cost of COBRA coverage for qualified beneficiaries starting April 1 and ending just a few days ago as of September 30th for certain types of qualifying events, which were involuntary termination of employment or reduction in hours. So where those items triggered, you know, an end of coverage and triggered an individual's COBRA rights, there was a 100% subsidy available for the COBRA for these months this year. There were special COBRA election notices that needed to be provided to individuals that alerted them to the availability of that subsidy and allowed them to elect that subsidy, even folks who had not previously elected COBRA. There was also a new requirement to notify individuals at least 15 days before the end of that COBRA subsidy that the subsidy was ending. So several, you know, aspects of ARPA did affect COBRA and COBRA administration. Those items now are over. There was no, you know, extension of that September 30 deadline. So you should be confirming with your COBRA administrator, or if you're internally administering COBRA, that you've sort of reverted back to I'll say somewhat of a normal process. We're still not within the normal COBRA rules and deadlines because, as Kim referenced during her comments, we have this outbreak period during which the deadlines are extended for at least a 12-month period. So those affect deadlines for electing COBRA, they affect deadlines for paying premiums, and they also affect deadlines for providing notices. The last development that is impacting COBRA is some recent litigation, and if we could go to the next slide, that has been filed against primarily kind of targeting large employers, including Amazon, Costco, Starbucks, the employers listed here. Many of these lawsuits have settled after not being granted motions to dismiss. So we don't really know exactly how the allegations of the plaintiffs in those cases would have, you know, panned out at an actual, you know, trial and with a court opinion. But these cases involve plaintiffs arguing that due to what we would consider very minor and maybe technical foot faults in the COBRA election notices, that there was a violation of the COBRA requirements. And I think in most of these cases, the employer or the COBRA administrator was not following word for word the Department of Labor model notices. And so that was the basis for those challenges. So, you know, very minor things like the notice provided the name of the COBRA administrator, but the COBRA administrator was not the technical plan administrator or plan fiduciary. You know, in another situation involving allegations against Home Depot, you can see that the notice directed plan participants who wanted to elect COBRA to sort of a general, you know, HR phone number to enroll in COBRA, or sort of a general website that was operated by a third party to, you know, for more information about how to make their elections and enroll. In that case, the allegation was that because the actual packet itself did not contain the actual election form or much more detailed instructions about, you know, go to the website, click here, you know, pull this down, etc., that those notices were deficient. We also saw an allegation against Costco in their complaint that a pretty common, I think, statement at the end of a form, really almost any form that an employee is filling out, was alleged to have misled a participant and made them feel fearful about actually exercising their right to elect COBRA. It said, as is reproduced here, that the person is certifying that the information they're providing is correct and complete, and warning them that if they make misstatements, that it's fraud, and that can have consequences. So again, we don't really know yet how a court would rule on these allegations, but I think the message is it might be a good opportunity in time, if you haven't done so recently, to really take a close look at the COBRA notices and election packages that are being used for your plan, where at all possible, they should really follow very closely, if not exactly, the Department of Labor model notice in order to maybe avoid these kinds of allegations being lodged against the company. And another reason to look at it is because we're in this extended deadline period. You want to make sure that those deadlines are being very clearly communicated to participants about exactly when they need to make their election, how long they have to make their premium payments, and to make sure that the information and notices that were created as part of the Cobra subsidy are now no longer being used in communicating information about the subsidy. A word on this extended grace period, which is sort of just but one deadline associated with COBRA that is currently extended. So the normal COBRA rules provide that you must provide participants with a 30-day grace period for making their premium payments, and that you can't cancel coverage while they're within this grace period. Now, some plans choose and did choose to provide longer grace periods. Maybe they gave 45 days, maybe they gave 60 days. But of course, we now have a mandated, extension of that grace period for based on that while we're in this outbreak period. Because the grace period has been extended, a lot of employers have and did reevaluate exactly how they handled coverage during this grace period. It was one thing to go ahead and continue coverage for a 30-day grace period and then sort of cancel coverage, maybe retroactive to the last 30 days when payment is not received. It's a whole nother thing to continue coverage for up to a possible 12-month period without receiving any payments from the plan participant. And so the other option that is available for handling COBRA coverage during this grace period is to basically cancel coverage, but subject to retroactive reinstatement and retroactively processing of claims that were incurred during that period, when and if you eventually do receive timely payment from the participant of the premium payment. The thing to keep in mind is that if a provider calls and inquires about the status of a person's coverage, they need to be provided with a complete answer. It can't just be this person has no coverage. It has to be this person's coverage is sort of pended because we're waiting to receive COBRA premiums, and will be reinstated if we do. So these are all things that if you haven't thought about, you should be thinking about. If you did think about it and you changed the way that you were going to deal with the grace period, when the outbreak period does come to an end, you probably should reevaluate, how you're going to handle coverage during the grace period. I mentioned the Cobra subsidies. I do just want to reiterate that one of the things that is left to be done as it relates to this subsidy is to make sure that you did receive the information that you needed to receive from the Cobra administrator regarding, who elected the subsidy and the amount of that subsidy, because of course it's based on the option that they elected, the employee versus family coverage. And that you receive that information in order to take the credit on the payroll tax return for the second and third quarters of this year. And if you did not get that information, then you may need to, if you want to take the payroll tax credit, I guess you could forego it. But But if you want to take it, you may have to actually work with your payroll group to file an amended return with that information included. And make sure that either you or your provider is retaining that documentation that supports the payroll tax credit that you do eventually take. As a reminder, you do get to take, the credit can include that 2% administrative costs, which you were not permitted to charge and were required to cover during that subsidized period. And you are not allowed to take the credit with respect to any portion of the coverage that you were voluntarily providing, let's say under the terms of a severance agreement or a severance plan. So if the employer already provided for subsidized coverage on a voluntary basis, you're not supposed to be taking the payroll tax credit for that. Having said that, this is a time to think, okay, did we maybe stop providing subsidies during this period when it was mandated, and now we want to revise our programs to add back a subsidy? That's another thing to be thinking of as this ARPA relief comes to an end here. I think I just went through all of these points on the considerations for employers.
Great. Well, then we will turn to the Consolidated Appropriations Act and getting ready for that. Starting off with just an overview of the surprise billing changes, just so you know conceptually what this means. Before the No Surprises Act, as part of the Consolidated Appropriations Act, we had some protections for emergency services under the ACA. So prior to the No Surprises Act, if you had emergency services, the ACA indicated how much you could charge participants for cost sharing, and it had to be, the same amount that you would charge for in-network services. But there were no rules on what you could charge participants for cost sharing for any other out-of-network services. Under the No Surprises Act, the amount that you can charge a participant is limited by law. And so we've got some interim final regulations that work through the amount that you're able to charge the participant, but just know that what you have in your plan right now, as far as what participants may need to pay as cost sharing for these services, is going to change with the 2022 plan year. Similarly, we had some protections under the ACA for what you pay a provider for emergency services. So there was a floor that you had to provide the provider at least a certain amount so that the participant wouldn't end up being balance billed for a whole lot of money for an emergency service. Now, there were no similar rules for non-emergency services. The plan could pay a provider whatever it wanted to. And so the plan was designed to identify how much it was going to pay an out-of-network provider. Well, under the No Surprises Act, we have a very specific amount that we have to pay the out-of-network provider. And the very specific amount is essentially whatever the plan and the provider agree the provider is owed. So if there is a state law that applies, if there is a state all payer model agreement that applies, that's going to govern the payment. Otherwise, the plan and the provider are going to negotiate. And we'll get into the process here in a minute, but essentially the plan payment is whatever the two parties agree that it is. And then prior to the No Surprises Act, the non-network provider could balance bill the participant for anything that the plan didn't pay. And under the No Surprises Act, for these services that are subject to it, the provider cannot balance bill the participant. Now, I want to just highlight for a moment something for grandfathered plans. So if you don't have any grandfathered plans, take a little rest. We'll get back to you in a minute. But the No Surprises Act enhanced the emergency protections of the Affordable Care Act. And they did that by sunsetting Affordable Care Act, Public Health Service Act provision 2719A. Well, 2719A didn't only include the emergency provisions, it also included the other patient protections. And you may be familiar with these because we have to put this patient protections notice in SPDs when we talk about the ability to choose a primary care provider. So the Affordable Care Act patient protection provisions applied only to non-grandfathered plans, but the No Surprises Act applies to grandfathered plans. So the No Surprises Act picks up this section of the Public Health Service Act, drops it into the No Surprises Act. So although the patient protections themselves haven't changed, they have become applicable to grandfathered plans. So if you have a grandfathered plan, that plan is going to have to start complying with these protections and include the patient protections notice. So the surprise billing process, the way this works generally is The non-network provider is going to submit a bill to the plan. The plan then is going to determine what, under the terms of the plan, is payable to the provider and send the provider the payment or a denial of payment notice. If the provider is unhappy with that payment amount, they can open negotiations. There'll be negotiations between the provider and the plan. If those negotiations are not successful, then the provider can initiate binding arbitration, where essentially, and this is baseball arbitration. So the provider says, this is what I think I should be paid. The plan says, this is what we think the plan should pay. The negotiator, the arbitrator, then takes into account both offers, considers a bunch of different factors, and comes up with one or the other. So there's no compromise at this point. There's no mediation. They pick one or the other. And whatever is picked, that is the plan payment for the out-of-network service. Moving on then to some transparency requirements under the Consolidated Appropriations Act. We did get some guidance from the regulatory agencies to let us know what guidance to expect generally and when. So we have a lot of these requirements that were supposed to come into play. The first one was December 27th of this year, and then we have, depending on the plan year, the first day of the first plan year beginning on or after January 1, 2022. Well, no, implementation FAQ 49 went through a number of these requirements and said either we're delaying this requirement until further notice, or we're delaying it until a specific time, or we're not delaying it, but we know we're not going to get guidance out. So just do the best you can with a reasonable good faith interpretation of the rules. There are a couple of these items that I'm going to highlight here in slides in a minute, but just wanted to note that I think this piece of guidance was the green light for our administrators. And spoiler alert to the end of the session, most of these requirements will be handled by your third-party administrator if you're a self-funded plan, or the insurance company if you're a fully insured plan. And so much of this is going to be just a matter of getting the vendor to agree to do this for you. But let's focus on a couple of these where you may have some actions of your own. The first being gag clauses. This requirement was effective the day the law was signed, December 27th, 2020. And it says that a plan cannot enter into a contract that prevents the plan from sharing information or using information in the ways noted here on the screen. So if you are entering into a contract, if you're renewing a contract with a healthcare provider, network, association of providers, third-party administrators, other service providers offering a network of providers, the contract with that vendor cannot include these prohibitions on using and disclosing this information. And so be very careful when you're renewing these contracts, entering into these contracts going forward, that they don't prevent you. I've been trying to put a catch-all clause in contracts saying, notwithstanding anything else to the contrary in this agreement shall not be interpreted to prohibit us from doing these things. And so far that's not been successful because the vendors are saying, no, we're going to deal with CAA stuff later. Well, this is not later. This requirement is effective now. So it's something that you really should push on. Second is the surprise billing notice. So the CAA requires plans to make publicly available, post on a public website, and include with each EOB that deals with a service that is subject to the protections, a notice about the surprise billing protections. There's a model notice from the Department of Labor, which has some customizations on it, essentially for plans that have more restrictive state laws that would apply to that plan. So if you're a self-funded plan and you're not opting into any state balance billing protection laws, then you probably don't need to add any state-based provisions. But if you're a fully insured plan, then it makes sense to work with your insurance company to figure out, well, what are those state protections that apply? What's the insurance company's notice going to look like? We want to make sure our notice looks like the insurance company's notice, and we're describing the same protections to our employees. What does it mean to make the notice publicly available or to post it on a public website of the plan? Well, the agencies very helpfully told us that they're not going to tell us. So we need to go with a good faith interpretation of those words. Most employer sites that I know of, the employers that I work with, have benefit sites that have login credentials, right? It's an intranet. You have to log in. It's not publicly available. Is that a public website of the plan? It's hard to say. Asking one of the representatives from the Department of Labor last week, they sort of, that doesn't sound like it's publicly available. Like, well, okay, well, what if my TPA posted on their page? Is that a public website of the plan? Well, we kind of have to tie it back to your plan somehow. So this is something that, you know, as we get closer to 1/1, something worth working through is how are we going to make this publicly available without creating a brand new public website, which I don't think you have to do. What's the best way to make this publicly available? And then ID cards, you've probably gotten from your TPA a notice that says, here's the picture of the ID card we're going to be issuing next year. And most of the TPAs that I've seen have said, we're going to add this information to the electronic cards. We are going to include it on any new cards that we issue, but we are not going back and reissuing cards to all of your members. I think that's probably a reasonable interpretation of the law. And again, we're going with a reasonable interpretation because it does say on any physical or electronic card issued to. So technically the cards that, I mean, they have been issued, but they weren't issued on or after the first plan year that begins on or after 1/1/22. So, you know, at this point, I think that's probably a reasonable good faith interpretation, but pending guidance, we'll have to see. So considerations for employers. This is the big one. If you haven't already been working with your vendors, make sure you know what they are not going to do for you. And so you've got time to get that into place yourself or with another vendor. You need to know, are they going to need any information from you? Are you going to be asked to make choices or elections? If so, you want time to do that before they need to come into compliance. And most importantly, we want an amendment to the services agreement that protects you if they don't do what they say they're going to do. So depending on the terms of your underlying services agreement, this amendment may need to, you know, add the additional services, say what the vendor is going to do, what are the additional fees that are going to be charged, do we need additional indemnification provisions in case they don't comply, do we need another statement that says they're going to do this in compliance with the CAA, and it's very important because we have a fiduciary obligation to monitor our service providers and make sure our plan is in compliance. Do we have an ability to monitor their performance and to verify that they are in fact complying with the rules? And because a lot of this information is going to be electronic, do we have sufficient data security provisions in our agreement, or is this a time to update those? From a plan perspective, you know, you want to be sure that your service provider agreements don't have gag clause, any ones that you're entering into going forward. You're going to want to make sure you're aware of the surprise billing notice and figure out how to post that and how to draft it. And then your 2022 SPDs are going to need to be updated to reflect the new requirements for the cost sharing amounts for the services that are subject to these protections. You know, the payment amounts, I'm sure that the definition of recognized charge is going to need to be updated to reflect what's actually going to be paid to a non-network provider. That the definition of emergency services was enhanced by the Affordable Care Act, or enhanced the Affordable Care Act definition, so that definition will probably need to be beefed up in the SPD. And if you're a grandfathered plan, don't forget about adding that Patient Protections Act notice. I'll turn it over to Laura.
All right. So a couple of things, we're going to hit these real quickly. We've had a few questions come in, but I think some of them were already addressed. One was whether or not this deck would be, this slide deck is going to be available. Yes, it will be sent along with the recording of this session. So feel free to enter questions in the question tab and we can address them at the end here. Couple of reminders, your cafeteria plan document should be reviewed to determine whether any amendments to that document may be necessary. In general, we do have some extended deadlines for making amendments to cafeteria plans that were given to us as a result of the pandemic situation and the different relief that was issued that impacts cafeteria plans. The general rule is that amendments must be adopted if necessary, based on your plan language, by the last day of the calendar year beginning after the end of the plan year in which the change is effective. Now, that's pretty straightforward for calendar year plans, but if you're a non-calendar year plan, that you need to do some math to figure out exactly when your deadline is. These amendment deadlines here that are indicated on this chart are sort of assuming a calendar year plan. I'm not going to go through each one, but you know, there might be some amendments coming up here at the end of this year, and then a few to have on your radar for next year. The other thing we wanted to mention is that, you know, of course, as you hopefully all know, there is a whole series of notices that are required to be provided to participants in group health plans on an annual basis. Those include the notices described here, and for the most part, the model notices, there have been no changes to the notice requirements or the model notices upon which they're based as it relates to the ones listed on this slide. The Section 1557 notice was basically under the non-discrimination provisions of the Affordable Care Act, and didn't apply to every group health plan. In general, it applied to group health plans sponsored by employers that received reimbursements from certain federal governmental programs. So, for example, hospital group health plans were subject to it because they're receiving, payments from Medicare, Medicaid type arrangements. But that notice is now no longer required for those plans. There has been an update to the CHIP notice. The latest and greatest is dated July 31st of 2021. This is the notice that informs really all employees, and that's a call out. This notice is supposed to go to all employees living in the states listed in the notice, not just to, active participants in the group health plan regarding certain types of premium subsidies that might be available through their states. Also, as a reminder, there are specific requirements around, how these notices, can be delivered and how they can, can't be delivered, what doesn't satisfy delivery of the required notices. We did have, during the duration of this outbreak period, the standard that we're held to is that notices should be provided may be provided to participants electronically, even if the normal rules governing electronic distribution might not otherwise be satisfied. If you believe that is the most effective way to ensure delivery of those communications. I think this was primarily in recognition of the fact that during the pandemic and continuing to today, we have a lot of sort of remote workers and workers operating under different circumstances than they normally would, performing their duties in a different possible way and manner. But otherwise, the general rules apply. The ERISA requires that these materials be distributed in a way that's reasonably calculated to ensure actual receipt of the materials. That's sort of the baseline criteria. There is a safe harbor for electronic distribution. It's very clearly permitted and deemed to ensure that it reaches participants if either the participant has consented to electronic disclosure or if the participant hasn't consented, if the criteria on this slide are met. There are some different nuances, unfortunately, that apply to certain types of notices. We've kind of outlined them here. I don't think I'll go through them in detail, but be aware that there are some slight differences in how you must or are permitted to deliver these notices based on the type of notice. Also, as we're talking about and looking at enrollment materials, which is another, communication that we know is going out at this time of year, it's a good time to remind ourselves that if we are offering benefits that we're intending to treat as purely voluntary, and by that I mean that qualify as not being subject to ERISA under a safe harbor that the Department of Labor has outlined for us, we should really avoid either mentioning them at all in our open enrollment materials, or if we're going to mention them, very clearly delineate them as offerings and products that we're not endorsing, that are not part of the ERISA governed plan. Again, because one of the criteria of the Department of Labor safe harbor is in order to treat them as not subject to ERISA, we have to avoid the appearance that the employer is endorsing these programs. As a reminder, in order to meet that safe harbor, they have to be completely voluntary. The employer cannot contribute in any way to the cost of those benefits or subsidize them in any way. The employer can't receive consideration in connection with the program other than, to cover administrative costs. And really, the employer's involvement needs to be limited to permitting the insurer to publicize the program, collecting premiums through payroll deductions. That is a permitted involvement, and then remitting the premiums to the insurer. And we already, talked about these points. Other 2022 planning considerations as we head into next year. This slide lists all of the applicable limits for the 2022 plan year. The items in red are really kind of, normally the limits are going up. These are going down, and especially the affordability percentage. Take note that threshold has gone down, and in particular, if you're using FPL, stands for federal poverty level affordability standard. There's 3 different safe harbors that you could be using, one of which is the federal poverty level. If you're using that one, then the monthly premium that you charge for your lowest cost employee only option can't exceed the dollar amount noted in that threshold for 2022. So if you have pockets of your workforce for which you're very, very close to that affordability threshold, take particular note of these adjustments. And then, of course, with the D-Cap limit, the dependent care flexible spending account contribution limits, we had some COVID-related relief that allowed, those contributions to go up to the 10,000 and the 5,000, and those will go back down in 2022. Finally, and this will be discussed in a little more detail in next week's program, but it's probably a good time to really take a look at where your plan design may differ from what the TPA considers their standard plan designs. We're hearing that a lot when we're reaching out to TPAs to discuss compliance with the CAA requirements, and they're saying, well, if your plan uses our standard plan design, then we'll agree to do all of the additional new requirements and take care of that for you. Specifically, for example, mental health parity testing that we perform will apply to your plan. But if you're not on our standard plan design, then all bets are off, and good luck to you in figuring out a way to ensure compliance. So it's just a time to really pause, and if you aren't clear already whether or not you have a standard, whatever the TPA considers or standard plan design, you may want to take a look at that, understand where those variations are, and really consider, do we even care about these variations? Maybe we need to move to the standard. Also, I want to call out, we are seeing an increased number of employers adopting what are called point solutions, or maybe centers of excellence, where there's a specific provider that is being engaged to provide a specific type of service. All of a sudden, I'm forgetting what are the. Give me an example, Kim.
Oh, like carve out fertility.
Yes, exactly. A carve out fertility provider, and the call out here is. Telemedicine could be another one. Even
second opinion services.
Exactly. It's important to think about those and the issues that are raised when you're adopting those. Are they part of your group health plan? Does the offering of this benefit, does it need to, and does it comply with the ACA requirements, with COBRA requirements, with HIPAA requirements? So those are just things to be carefully thinking through if you're adopting these sort of point solution offerings. Drug manufacturer coupons and copay assistance. I mean, this has been an item for a number of years, but make sure you understand how your PBM is treating drug manufacturer coupons, specifically whether or not the benefits that are being paid through the coupon are counting or not counting towards the deductible and the out-of-pocket maximums, and make sure that your communication to participants about that is clear. Essential health benefits. If you're adding an annual or lifetime dollar limit, or if you will newly be excluding a benefit from the out-of-pocket maximum, you need to confirm and identify a benchmark plan that supports the exclusion of that benefit or the application of an annual or lifetime benefit limit to that part of your plan. Because remember, we can't apply annual or lifetime dollar maximums to anything considered an essential health benefit under the Affordable Care Act. Other issues to consider will be addressed in next week's presentation. Let's see, we are right at our time. Looking to see if we have any. I think we've addressed all of the questions. Again, thank you very much for joining us today. As a reminder, there is CLE and HCRI credit. You will need to complete the attorney affirmation form on in the upper right-hand corner of your screen to receive credit. The code that you will need to complete that form is TH106. T as in Tom, H as in Harry, 106. We'd also appreciate it if you take a few minutes to complete the feedback form. Thank you for attending. And as I meant, if you have any questions that we were not able to get to today or we aren't able to get to next week, feel free to reach out to Kim or I or another attorney in our employee benefits practice group. Thank you.